Hey everybody, welcome back to another episode of Debt Collection 101 here on Our Bite You. And today we have a very exciting topic to talk about, as well as an awesome guest who doesn't really need an introduction. But we're going to be talking about the Hunstein case with our guest, Rick Perr with KDV. So everybody knows him in the industry, doesn't really need an introduction. But Rick, if you could just tell everybody watching about yourself.
Sure, I appreciate it. Thanks, and thanks, Alex and Ashley and everybody for having me. Always a pleasure to talk with you, and we appreciate your support of the industry and the work that you guys do. I'm Rick Perr. I am the partner at Kaufman, Dolowich Voluck, located out of the Philadelphia office, where I'm a co-managing partner, and I am chair of the firm's nationwide consumer financial services practice. So, been doing this for a long time. Also had a little bit of a stint with ACA on its board of directors and served in a small role as president for a year. So other than that, just a regular guy trying to help the industry out.
All right. Well,
Awesome.
Yeah, thanks so much for joining us and talking about this. So, but we'll get into it. And for anybody who's maybe not familiar with the Hunstein case, I'm sure everybody is by now. It's been the talk of the industry for quite some time. But if you could give us a little bit of a background on it. Yeah.
Sure. So the case develops out of just a run-of-the-mill litigation. Look, we as attorneys and even as agency owners who are dealing with these cases, we always see what I'll describe as novel theories. In most cases, situations that people just try and completely misinterpret the FDCPA, and they bring a lawsuit hoping to get a few dollars out of an agency or a defendant. This was one of those cases. In which the allegations took a look at 1692 CB, and what that section of the FDCPA says, and as everyone knows, you can't communicate with a third party about the fact that a consumer has a debt. Right? It seems pretty straightforward. Seems pretty simple. There's no third party disclosure. So the novel aspect of this case wasn't that they were saying that there was third-party disclosure because somebody went to a neighbor or a friend or decided to talk to an employer and say, guess what? John Doe owes a debt. Instead, what they alleged was the mere transmission of information from the agency to the letter vendor constituted third-party disclosure. And at the trial court, they filed a motion to dismiss, and the trial court granted it, obviously, and what was as to be expected. And so the case was dismissed. They said the communication wasn't in connection with the collection of a debt because they weren't trying to collect the debt or talk about collecting the debt with the letter vendor. The letter vendor was merely a conduit for which you're going to supply the information and send it on. Suddenly, plaintiff takes the case up on appeal. And during the course of the oral argument, things take a little bit of a turn where the panel of judges starts asking questions, not just about the merits, but about whether or not plaintiff has standing to even bring the suit. Standing was never raised at the trial court level. And so there was this overly aggressive oral argument. The result was that the panel, in a unanimous decision, concluded that A, there was standing to bring the claim. In other words, that it could be brought in federal court and the plaintiff had enunciated a harm, and two, that in fact there could be a cause of action for this type of conduct. Now, it was at the motion to dismiss stage, so the court recognized that there needed to be some discovery to determine whether or not a violation occurred. At that point, we became involved and filed a petition for a rehearing en banc, which sought the entire court to get together and rule on these issues. In the meantime, the U.S. Supreme Court issued a case, TransUnion versus Ramirez, in which it re-highlighted the limited basis upon which standing could be granted in federal court, even saying in a footnote that dissemination of information to a letter vendor probably does not constitute publication. So what happens next? The panel that originally issued the opinion reissued their opinion, this time in a 2-to-1 decision, and said TransUnion didn't apply the way that everyone was interpreting it too, and doubled down that there was a violation and there was standing. One of the judges switched his opinion to say that there was no standing, and even with there wasn't any standing, he didn't think there was a cause of action at this point in time. Shortly after that opinion came out, the entire court decided to take it all up on a rehearing en banc. Oral argument was held February of 2022, and now everybody waits for a decision. So the court is faced with a couple questions. Question number one is there standing or no standing? If there is no standing, meaning that a claim can't be brought in federal court, doesn't mean the claim can't be brought, just not in federal court. It can be brought in state court. Then the case will just be sent and it'll start up all over again from the very beginning in state court. If the court decides that there is standing, and that's taking all of the judges who are on the entire panel for the 11th Circuit, then the court will have to decide whether or not there is a cause of action. Will they affirm the decision of the trial court, or will they say and adopt the similar rationale of the panel opinion, which has since been vacated, and say that this is a cause of action that can possibly go forward? Clearly, saying that this is a cause of action that can go forward is not the desired result of anybody in the industry. And what we have seen is copycat claims that have popped up throughout the entire country, not just dealing with letter vendors, but theories about communications to other vendors. We even have seen what I call the and everyone will appreciate this if you're a fan of Loki on Disney Plus, but I call it the Hunstein variant, which is a claim that says if a debt buyer sends the account to a collection agency to collect, plaintiffs have made the claim that that's a communication because they're considered a debt collector and they're sending it to somebody else and they're transferring the information, that constitutes a Hunstein style claim. So we are seeing that deviation from just what's out there, and it's definitely a big issue. Now, what we do know is in a lot of areas, the federal courts are saying there is no standing in other circuits and elsewhere, and having these cases sent back to state court, which opens up an entire horizon for this industry, which is used to litigating our cases in federal court, to starting to have to deal with these things at the very local level with judges who are not familiar with the FDCPA. Doesn't mean that we don't win or that there's any less of a chance of a win, but what we're not going to see is a series of uniformity amongst decision makers, and just because a judge in Colorado rules one way is not going to be persuasive for a judge in Florida, the same way that if a Colorado district judge had issued an opinion, it would have some persuasive effect on a Florida district judge. So the story still remains to be written, and there's going to be a lot of issues out there for everyone to deal with, and for those of us on the defense side. Unfortunately, we're going to be kept busy probably as opinions start coming out for at least another year or two before anything can be determined.
This case has been out for so long, and I always feel like I've just in an episode of The Twilight Zone every time it comes up. It just boggles my mind.
There's just so much to it, so much reach on different things. Like, it's absolutely insane. But I think you kind of touched on this a little bit on the rehearing part. I know it's newer, less than a month that this started happening. But can you just speak on why the rehearing is taking place?
Well, the rehearing is primarily being taken on the issue of standing. So the whole world got turned a little bit upside down. And standing's not a new issue. I should start by saying that there was a case called Spokio that was back in 2016. Some agencies and lawyers had taken advantage of it and tried to argue to a lot of federal courts that this case shouldn't be here. It needs to be dismissed. The federal court doesn't have jurisdiction if there is no actual harm to the consumer. And as many of you know, with the FDCPA, a lot of the statutory claims don't have harm. It's you forgot a letter in a word. You said something that maybe wasn't entirely accurate, but it really was like no harm, no foul. And so courts were reluctant to fully embrace the Spokio opinion. And even though plaintiff defense lawyers had tried, he probably, for the most part, wasn't that successful. Although, again, strategically, I don't know the value of having something in federal court versus state court, that there was a desire to have it in state court. I think a lot of lawyers thought that if you got it dismissed from federal court, the plaintiffs wouldn't bother to refile in state court, that they didn't want to be there. So Spokio goes, and it's pretty much been hit and mostly miss with getting cases dismissed. And then TransUnion comes out, which fully embraces this no injury, actual harm concept. And now all of a sudden we are seeing federal courts across the country on not just Hunstein claims, but on lots of claims saying there is no actual harm. We're not hearing this in federal court. It's almost a docket cleansing that's taking place. Again, it's not a merits decision. These cases are still going to go on in state court. And so the focus of the rehearing in Hunstein was, is there standing or isn't there standing? Could Mr. Hunstein bring his case? A case of the information was transferred. We don't know who saw it or not. And quite frankly, even if somebody saw it or did something, was there any harm to you? Not like it was published anywhere. Nobody took out newspaper ads. It didn't go into the internet. He didn't lose money. Any of those things that would constitute some type of concrete harm or injury. And that's the primary focus. Again, secondarily, if they decided there is standing, that they would have to really address the trial court's opinion, which was, okay, there's no claim. It wasn't a communication in connection with the collection of a debt. You know, there are some testing out there that some circuits have suggested that not every communication between a debt collector and somebody else is about the collection of the debt. It could be something along the lines of, do you have an attorney? Can you send me your phone number again? You know, do you have insurance information? You said you were going to send it to us. We're going to, you know, please send it back to us. There could be communications all the time that have nothing to do with the actual please pay me aspect of debt collection. And so the argument, again, at the trial court level, which had nothing to do with standing, it wasn't a blip on anyone's radar, was giving information to a letter vendor was not an effort to collect the debt from the consumer. It was an effort to tell the letter vendor, here's the information to put in the letter so you can send it to the consumer to collect the debt. It wasn't in connection with the collection of a debt. Now, the panel initially said in the panel appellate opinion that it was in connection with the collection of the debt. By sending that information, it was to facilitate the collection of the debt. You know, the argument is it's not to facilitate it like you're trying to collect it or to institute collection with the letter vendor. That's not who it is. It's different than communicating to a friend or neighbor, where the purpose of disclosing the information to the friend or neighbor is presumed to apply some sort of pressure on the consumer. Because if your neighbor comes up to you and says, look, I've been called by this debt collection company, your embarrassment is going to spur you into paying. That's not what was being done here, and that wasn't it. And so the question becomes, is even if they say there is standing, that it still should be dismissed. And you know, that's a fingers crossed, hopeful result to get an opinion like that. And I can tell you that litigating these cases across the country, we're trying to get a result similar to that from trial courts across the country. It's an effort, and we've been filing motions. We probably have about 10 to 12 of Hunstein style motions in cases that we're handling, waiting for judges to issue opinions, hopefully saying that there is standing and that there's no cause of action, because that would be the best thing we could do for the industry. Start having that proliferate rather than the original Hunstein decision.
So not to go down a giant rabbit hole, but obviously this is a possibility. And you know, you kind of hinted at it a little bit with the copycat cases, but what are some of the implications for the industry if the 11th Circuit comes to the same decision?
Well, the good thing, well, look, the 11th, again, there's a couple different areas. If they say there's no standing, then it doesn't change anything. We start at square one again in 11. And there's still, 11 other circuits out there that have to come to conclusions. So, the way that our judicial system works is we have 92 district courts. We have 12 judicial circuits. They all get to rule the roost in their own geography, only cut off by the U.S. Supreme Court, which oversees all of them. The likelihood of this case getting to the U.S. Supreme Court in any form is not high, just because the nature of the case. It's just not, the U.S. Supreme Court tends to take high-profile issues of law. That's how you get TransUnion Ramirez. That had to deal with standing. How can you get into federal court for a class action in that case? There was a lot at stake that could apply to other cases. Interpreting what does the FDCPA say, while it has happened in the past, it's just not a likely event. It's just not sexy enough for the Supreme Court, and it doesn't affect enough people for them to take that up with their heavy docket. So you're still going to be fighting this in 12 other circuits and in 92 other district courts, and trying to get to a point where plaintiffs' attorneys decide to stop filing these cases becomes a win for the industry. I'll give you an example. We filed a case very similar in Pennsylvania, a motion. The judge mirrored the original Hunstein appellate decision and said, look, I think there's a cause of action, but you got to go through discovery first. Getting a court to say after discovery that because nobody saw this at the letter vendor, there's no cause of action, it's just as much a win as getting it thrown out in the first place. Because plaintiffs' attorneys are then going to have to say, am I going to find the one plaintiff where the letter vendor picked that letter for quality control, and I just happened to do it? And in the meantime, I'm spending thousands of dollars of time to try and guess that I found that guy, and I'm not going to figure that out until after I get through discovery. So winning those type of things, even not winning on the motion to dismiss, but maybe winning on summary judgment or winning at a trial, may be enough to deter plaintiffs' lawyers from bringing these claims, because if they don't see the money at the end of the rainbow, there's no benefit for them to invest in it. So, that's why I said it may be, regardless of what happens in the Hunstein decision itself, we're going to be fighting this for another couple of years.
Yeah, this is crazy. But it sounds like it is gonna be more so wins than losses. It seems like you have, I don't know, your outlook on it seems very positive, which I think people watching will very much enjoy that.
Well, I think that it's positive. Look, we have some judges that have said some things, but we've had more judges that have indicated they just don't think this is a thing. Mm-hmm. Now, granted, that's been more in the standing cases where they say there's no standing, but they follow it up with there's no standing and we can't even see the harm in this practice. Mm-hmm. You're hopeful that you can use that language for those cases in state court and get state court judges to just simply say, this is ridiculous. And we all know it's ridiculous. That was not what the intent is of that particular section. It was all about communicating to other people in an effort to coerce the consumer into paying the debt, juxtapose against the exposure of the fact that they're a debtor, right? Mm-hmm. We're going to tell other people that you're a debtor, it's going to make you pay. And that's what the law was written for. It was never written to say that company A can't outsource its very simple processing. Because quite frankly, in 1978, no one's dealing with this issue. I mean, the technology's not there. They did talk about telegrams, though, and I don't know, one of the arguments we raised, how do you give something to a telegram person if that's an acceptable method of communication without giving the exact information that we're talking about? It's not as if I would walk in and type walk into right. Western Union, excuse me, please move aside. I have some debt collection communication going on here. I'll type the information into your computer and I will pull it out and give it to the carrier to send. That's not what was happening. It's no different than the letter vendors. So, You know, a lot of judges buy that. Again, it takes time to get there because that's just
Mhm.
not what this section was designed for.
Mhm.
Now it's been weaponized,
Yeah.
and it's been costing everybody a lot of money to get there. Thankfully, the industry has, for the most part, banded together in deciding to fight these cases and not cave in by giving settlements left and right. Industry partners such as yourselves have been there to assist in the fight. We've had a lot, whether it was in the amicus, the amici briefs by all of the industry participants that all jumped in. You know, I think there were 14 or 17, which was great, that everyone was stepping up to this challenge. And it's not just people in our industry, but people in the banking industry, the mortgage industry, that all see the proliferation of this style of exposure can be crippling to the processes. You know, nobody wants to sit there and all of a sudden have to bring everything in-house. We don't think that there's any benefit to the consumer to forcing that to be done. We need companies out there. We need vendors to take care of things. You know, that's how it works. It's better off, as you guys can attest to with the great job that you do. It's better off you handling it with your expertise than, you know, with all deference to a lot of my clients, having them and their employees start to do your job in-house. You know, and have to acquire that expertise. That doesn't make sense.
I think it would end up harming the consumer, I would say. Just,
Yeah.
So.
Yeah. Well, yeah, it's been great to see, like, literally the whole industry, you know, coming together on this. And I know when this first came out, it was all I saw: webinars on it, blog posts on it, emails from different people about it. So it gained a lot of views very quickly. So what can, and it scared both agencies and vendors. No one really knew what was going on. So what can agencies and vendors do to be proactive about this type of case happening again, which it seems like we will see these type of cases happening in the future?
Well, first is that look, there's no reason to panic. I think that all of the legal experts that look at this cause of action and look at things, you know, they can tend to tell when something's gone south or when a legal theory develops that causes some area of concern. Not to say that you should be reckless about it, but the uniform conclusion for the most part is that it's something that is ultimately winnable, whether it's in 11 or whether it's elsewhere, and that it is not going to proliferate throughout the country. And we have seen judges that are already going in a direction of saying this seems a little ridiculous. Mm-hmm. But there's nothing in, you know, short of bringing everything in-house, there's nothing you can do right now until there's a final determination, and again, a determination that's uniform across the country, to change what you're doing. For example, you know, there are people, I've seen a number of alternative theories of how can I print letters using other methodologies. The shared employee model, things along those lines. Everyone comes up with a good theory. The problem is, from a practical perspective, it doesn't mean that those theories don't work. It just means you get yourself to the same place. So it's not as if you're printing a letter, and on the letter it's going to say, this letter was printed through a co-sharing employee arrangement with the letter vendor, and therefore there's no violation of the FDCPA. It's not going to be printed on the letter. And even if it was, the plaintiff's lawyer is not going to not file the suit. So what's going to happen? You're going to be back at the same spot because you're going to have to use facts to prove what you're doing. It's not going to be a motion to dismiss. It's going to be a summary judgment. And I know I'm getting in the weeds of some of the technical stuff, but there's a difference between getting the case dismissed right away or having to go through discovery. And even if you accept the vacated Hunstein opinion as becoming similar law, the reality is all of us still believe that after discovery, there's going to be no publication. So we're going to win at that point. And so if you win at that point, it's the same thing. So trying some of these alternative methods, I don't think we're there yet to try and sell out and go in a different direction, because I don't think you advance the game or advance the ball. You're still in the same spot. You still have to get through discovery and get a judge to rule on summary judgment. So right now, no reason to panic. Just keep doing what you're doing. We'll let you know when it's time to put on the parachutes.
All right. Well, thanks so much, Rick, for sharing your input on this. Appreciate the positive outlook. As Ash said earlier, I think everybody else will appreciate that too. But yeah, that's all we got for you. But thank you so much for joining us.
No, my pleasure. Anytime. And thanks for everything you guys are doing.
Well, thank you everybody for watching and tuning in. Thanks, Ash, for helping the host, and we'll see you next time.